Good afternoon or good morning, everyone, depending on where you are. Welcome to the final webinar in Fasken's fall series, Breaking Up is Hard to Do, the Challenge of Just Cause Terminations. I'm Gillian Round, a partner in our Labor, Employment, and Human Rights group in Toronto. I work with both unionized and non-unionized employers across both provincial and federal sectors, including in financial services, aviation, transportation, telecommunications, and healthcare. And before I introduce my fellow speakers, I just want to quickly cover a few housekeeping items with you that you'll see on your screen. So I want to highlight that there is a survey that you can complete, as well as CPD certificate details. QR code links will be available at the end of the presentation for you to complete the survey and claim your CPD certificate for Ontario, Quebec, and British Columbia. Under the survey, we'd love your feedback. Taking a couple minutes to complete the survey really helps us improve and deliver content that actually matters most to you. So with that, I'll introduce my two co-speakers. So joining me today is Laura Epplett. Laura is an associate in Fasken's Toronto office, where she maintains a broad practice in labor, employment, and human rights. She advises both private sector and public sector employers on workplace matters such as labor relations, investigations, policies, and litigation. And with us is Brooke Levy, who's an associate in Fasken's Montreal office, also a member of our Labor and Employment and Human Rights group. She advises on all aspects of employment law, including hiring, terminations, human rights, employment standards, and has a particular focus on executive employment agreements and restrictive covenants. Brooke's background in corporate finance allows her to provide specialized guidance on employment issues and mergers and acquisitions for both Canadian and international clients. And so with that, we will move on to the presentation. So in terms of the topics we intend to cover, we want to cover a number of issues with you today, including the guiding principles that apply in just cause terminations, the types of employee misconduct that could warrant just cause for termination, and recent cases on those issues, the importance of progressive discipline, particularly with respect to unionized employees. While we normally think about just cause and we think about employee behavior, we'll also talk about some employer behaviors that could actually invalidate a just cause defense. We want to talk about situations when an employer may be able to allege after acquired cause in situations where they initially terminated without cause. The difference between the legislated and common law standards of just cause, and also the difference between just cause and frustration of contract. So I think the first thing we need to touch on is what is just cause? So just cause is often defined as the capital punishment of employment law. So in a situation where we terminate an employee without cause, that is generally treated as the employer breaching the contract. But on the other hand, when we terminate an employee's employment with just cause, we are treating the contract as having been ended by the employee as a result of their conduct. Generally, outside of Quebec and in some situations when we're talking about statutory entitlements, just cause means that no common law notice of termination has to be provided to an employee. But as we will discuss later, there are situations where they may still be entitled to statutory entitlements, even in situations where you terminate for just cause. The challenge with establishing just cause is that it is a very high bar, both under the courts as well as through arbitrators in the context of unionized employees. And because of this, it is really hard to know with any certainty if the just cause threshold is met in a given case. And it can take a significant period of time to build a case for just cause. And the reason why we need to build a case is that In most situations where an employer alleges just cause, that decision will be challenged in some forum, whether it is the unjust dismissal protections under the Canada Labour Code, the civil courts, an arbitration for unionized employees. So the cost of litigation can often be significant, and the potential for damages are also high if an employer is not successful in asserting just cause. But with that being said, it is not impossible to successfully terminate for just cause. There are still cases before the courts where the courts are holding or arbitrators are holding that just cause has been established by an employer. And generally, just cause will be established if the employer can show that the conduct by the employee is incompatible with his or her duties and that it goes to the root of the contract, with the result that the employee's conduct has fractured the trust and the relationship between the employer and the employee. And I'll turn it over to Brooke to briefly talk about Quebec.
So, in addition to what Gillian is saying, Quebec does mimic a lot of the same principles from the common law provinces, but we don't use the term just cause in our legislation. Instead, we pull from two different legislative sources. We pull from the Civil Code of Quebec, which refers to the term serious reason, and then we pull from the Act Respecting Labor Standards, which refers to the term good and sufficient cause. Now, for the purpose of the presentation, we'll go back and forth between Act and Code just to simplify referencing. But what constitutes serious reason and cause, although they are found in two different sources, they are treated as equivalent before the courts. So together, they make up what is just cause. And similar to what Gillian said in the common law provinces, the threshold for establishing just and sufficient good and sufficient cause is quite high and very strict. The employer has to be able to demonstrate that there is a serious objective reason behind the termination, and mere dissatisfaction or subjective complaints would not be sufficient to warrant what is cause.
So a lot of employers may ask, well, why does just cause matter? Why can't I just terminate without cause and pay out the employee? And there's several reasons why it matters, because in certain jurisdictions or in the unionized setting, just cause is actually a precondition to being able to terminate employees in most situations. So in the unionized setting, an employer cannot terminate unless they have just cause, unless there's a shortage of work or other situations which are provided for under the collective agreement. So in the unionized setting in particular, it's really important to properly implement progressive discipline, and keeping a clear documentary record can be critical to making out a case for just cause because it is necessary in the unionized setting. As well, in the federal sector, under the Canada Labour Code, the unjust dismissal protections in that legislation have effectively entirely displaced an employer's ability to terminate without cause, except for in limited situations such as during a restructuring. What this means is that federal employers effectively have to treat their employees as though they are unionized, and they cannot terminate without just cause for, say, performance reasons or other reasons, unless there is discontinuance of a function or lack of work, and you have to show that in an objective manner. Another reason why it's important is because if you do not have just cause, then an employee is entitled to common law notice of termination, which is typically based on factors such as length of service, position with the employer, age. If you have a very long service employee, their common law notice entitlements could be very significant. And so if you do not have just cause, they will be owed very large entitlements in many cases. So it is important, if you want to ensure that you do not have to pay those employees common law notice, that you establish a very good case of just cause, particularly for long service employees who don't have a history of discipline. And then the last thing is that a lot of employees will have contracts that will oust their entitlements if you can establish just cause for termination. They may still, as we talk about later, they may still be entitled to statutory entitlements, but they may not be entitled to other entitlements provided for in a employment agreement if they are terminated with cause.
Now, in Quebec, the rules around termination are quite different from what you might see in the other provinces or in the federal sector. We can break it down into two buckets. We'll start with non-unionized and then we'll go into unionized employees. For non-unionized employees who have at least 2 years of uninterrupted service with an employer, excluding senior managers, the Act provides very strong protections against terminations made without good and sufficient cause. So in these situations, if an employee believes they were terminated without cause, they have the ability to file a complaint before the CNESST, which is Quebec's Labor Standards Authority. This complaint can then get transferred to the Administrative Labor Tribunal, or what we refer to as the TAT. And in these instances, when cause is not proven, judges at the TAT have the ability to reinstate the employee into their position, as well as provide back pay from the date of the issuance of the judgment. And even in some instances where reinstatement is not granted, but the termination is still found to be unjust, the employee could still be entitled to back pay for the same period, as well as potential additional compensation for their loss of employment in any amount which the tribunal would consider fair in that situation. So this recourse is what we call a 124 under the Act. It's the most common form of recourse for non-unionized employees, notably because an employee who does elect to file a complaint under 124 can even be represented free of charge by a CNESST lawyer. So you can see it has quite an appeal for an employee. Like I mentioned, there are some exemptions to who can file a complaint under this. One is the 2-year uninterrupted service, and another is employees that are considered senior managerial personnel, as it's stated in the Act. Now, similar to the term cause or serious reason, there's no strict definition of what or who qualifies as a senior managerial personnel, but it generally refers to individuals who have substantial influence over the administration of the business and a high degree of decision-making power. So these are typically, we'd see like C-suite, CEO, CFO, senior vice presidents, or some senior executives, like depending on their level of integration into the business. Now, in addition to this statutory recourse under the Act, non-unionized employees also can pursue a civil claim under the code. So this civil claim would be for reasonable notice of termination. So they can claim damages, including an indemnity in lieu of notice, or even extra contractual damages like moral damages from mental stress. However, unlike the Act, civil proceedings do not allow for reinstatement. So the liability in this instance for the employer would be strictly monetary in nature. Importantly, the recourse under the Act and under the Civil Code can be exercised concurrently by the employee. So they can be done at the same time. And in instances where even an employer did provide sufficient notice or reasonable notice of termination under the code, it could not prevent the employee from still obtaining back pay and potential reinstatement in the event the termination was found to be made without good and sufficient cause. So you can see that the exposure is quite high for an employer. Also, in terms of timelines, recourses under the Act are generally faster than civil proceedings. So not only are they common because they could be, an employee could receive free legal aid, but it's also common because it's more expedite than recourse under the civil code. So typically hearings are heard within 16 to 24 months and judgments rendered between 28 and 32 months following the termination. On the other hand, a civil claim, while an employee has 3 years to file the claim, the hearing date can only be set about 18 to 30 months after the termination has happened. So we could see that the length of time is quite different. Now, distinctively, like I said, this recourse under the Act is only available once you've hit this 2-year threshold or if you're not a senior manager. So what happens for the employees that are left outside of this bracket, so under 2 years of service? For these employees, recourse under the Act would not be made possible. So an employer in this instance can technically terminate what we would say is without cause, so long as they're giving the employee reasonable notice. That said, there are other complaint mechanisms which are available under the Act, which we're not going to go into today, but like prohibited practice or psychological harassment. And these recourses are not dependent on any tenure of the employee. So employers still need to exercise a lot of caution when deciding to terminate an employee. Now, for unionized employees, the picture is completely different. Their employment conditions are governed exclusively by the collective agreement, which means the remedies under the Act or the code are not available. An employee who is terminated in a unionized setting must challenge this termination through the grievance and arbitration process, which is set out and detailed in the collective agreement. That said, arbitrators apply the same standard and analysis to what is good and sufficient cause, and reinstatement is a common remedy for when cause is proven. So we can see that in either situation, there is a large liability and large risk for the employer.
So, of course, we can't just make things simple. So, we have to ensure that there are different standards of just cause under legislation as well as under the common law. So there are two different standards that apply. What might be just cause at common law is not necessarily just cause under employment standards legislation. Typically, in jurisdictions such as Ontario, the employment standards legislation actually sets a higher bar for what amounts to just cause. The reason being that the standard is high because they want to ensure that employees receive some amount of monetary entitlements if they are terminated, even if they are terminated for what would be just cause at common law. And so the standard under Ontario's employment standards legislation, the Employment Standards Act, is willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So it's a very high threshold to meet. So in addition to proving that there's been serious misconduct, you have to demonstrate that that conduct was willful. So behavior that is careless or thoughtless or inadvertent won't meet this standard. You have to show that that misconduct was both intentional or deliberate. So the employee was being bad on purpose, essentially. And this is different from the common law standard or the common law test, which Laura will talk about shortly.
So in Quebec, like I mentioned earlier, we take a different approach compared to the other provinces because the concept is not defined in our legislation. Instead, we pull from two forms of legal standards, the code and the act. So we have serious reason and good and sufficient cause. While they are treated as equivalent, they together are what capture what we would identify as just cause. Now, because it's not defined in legislation, we pull our interpretation heavily from case law for guidance. And in terms of what it does constitute, our examples do resemble those of the common law provinces. So we do see serious disloyalty, breach of trust, theft, fraud, insubordination, repeated incompetence, and of course, harassment in the workplace. Now, we'll go over these in more detail later on, but that is just a general principle for you. Now, even though there is no statutory definition of cause or serious reason in either of our forms of legislation, the code does impose clear contractual obligations on both the employee and the employer in an employment context. So employers must provide work, pay, and protect the health, safety, and dignity of their employees. And in return, employees must act with prudence, diligence, loyalty, and maintain confidentiality. So because of this, we see that many of the breaches of trust and loyalty we see, these are what are at the heart of our just cause terminations. So the bottom line is similar to what Gillian said in the beginning, is it really comes down to whether the employee is honoring their part of the employment contract. And where they haven't, it's the employer that has the burden of proving it.
right, so now let's talk about establishing just cause. So I think we all know by now that adjudicators are very reluctant to find that an employer has just cause for termination because obviously this is an all or nothing for the employee. If just cause is established, especially at both the common law and the legislative standard, they're not entitled to any notice for their termination. This is going to be particularly the case where there is only a single incident of misconduct. So it will be a very rare circumstance when an employer is able to establish just cause without a good investigation and clear supporting documents. That will eventually be what will make or break the case for the employer. So on obviously the key test for establishing just cause comes from a Supreme Court case, McKinley, and the test is whether the employee's misconduct gives rise to a breakdown in the employment relationship. And this is seen from the perspective of a reasonable employer, taking into account all relevant circumstances. And so the severity of the sanction must be balanced against the misconduct, having regard to the fundamental nature of employment in an individual's life. And the employer bears the burden of establishing just cause and a balance of probabilities. And so there's about a three-step analysis to this test. The first will determine the nature and extent of the misconduct. So again, that will go back to the evidence, the records, the documents. And then there's a consideration of the surrounding circumstances. So this step is a consideration of the employee within the the employment relationship. So this is considered both from the particular circumstances of the employee as well as the particular circumstances of the employer. So with respect to the employee, the court will consider certain factors such as the employee's age, their employment history, their seniority, their particular role, and what the responsibilities of their role is. On the other hand, when it comes to the employer, the adjudicator will consider the type of business or activity that the employer is engaged in, any relevant policies or procedures that they have in place with respect to the misconduct alleged. They'll also consider the employee's position within the organization. So, for example, are they an executive? Are they a fiduciary? And then the degree of trust that is placed upon the employee. They will also have a consideration of various mitigating and aggravating factors, which we will discuss in a few slides in doing this analysis. And then finally, the third step will decide whether dismissal is a proportionate response in the circumstances. And basically, this is looking at whether the conduct is reconcilable with sustaining an ongoing employment relationship. The Supreme Court is clear that the purpose of this contextual approach is to determine whether the misconduct is such that it led to a complete breakdown in the relationship and that it's otherwise irreconcilable with ongoing employment. And obviously underlying that analysis is the principle of proportionality. So, as we've discussed, the onus is on the employer to establish just cause, and this is going to be established on a balance of probabilities, which just cause is a very high legal threshold to meet. Courts have said where the misconduct at issue may also constitute criminal activities such as theft or fraud, the standard of proof will be higher and will require clear and convincing evidence. Now, our advice would be ideally you would want to have clear and convincing evidence in all cases of just cause because the court is going to particularly, especially in cases of where credibility is an issue and that must be weighed, or where there is witness evidence or multiple versions of events, you'll want to make sure you have clear and convincing evidence that just cause is established. As we had noted, it's really an all or nothing decision. And this is a balancing act, of course. Obviously, sometimes employers want to proceed with terminating for cause, and they may have some, poor performance on their hands or some inappropriate conduct, and it may be bad, but it may just not be bad enough. And so it's really important to look at the circumstances and the evidence that you have to determine whether additional examples or evidence is required before deciding to move forward and terminate for just cause. This is particularly the case where termination for cause is more risky, such as in the unionized context or in certain jurisdictions, as we had mentioned before, in the federal jurisdiction in Quebec, where the possibility of reinstatement with back pay is present. So whereas in Ontario, you go all the way to the court determines you didn't have just cause, you're looking at damages. In these jurisdictions, the adjudicator can order that the employer reinstate the employee, and that's often with back pay and recognizing seniority. So there are some common grounds that we see for just cause, mainly in the buckets of misconduct and poor performance. Under misconduct, obviously theft and dishonesty are quite serious, and the root question in cases where you're looking at dishonesty is whether the trust is crucial to the employment relationship and if that trust can be restored. For claiming insubordination, there's additional factors that the court will consider, such as, was the order clear and specific? Was it reasonable and lawful? Did it fall within the scope of the employee's duties and responsibilities? Was there insubordination intentional? And the order has to have been serious and important in nature. Often we see a lot of cases of wanting to move forward with termination for just cause for poor performance. And that's usually going to be much more difficult to establish. These cases are really looking the standard at being serious or gross incompetence. And so the performance, again, it might be bad, but it just might not be rising to the level of cause. And in these circumstances, the court will look at, the employer will be forced to prove that they had established a reasonable, objective, and fair standard of performance. The employee had failed to meet that standard. They had received warning that their failure to improve may result in their employment being in jeopardy, and that they had a reasonable opportunity to correct that performance. So now I'm going to turn it over to Brooke to provide some perspective from Quebec.
So, like Laura said, there are two main buckets to, I guess, what you would call cause. And in Quebec, these are treated as two different legal concepts. We have disciplinary cause, which would be what Laura mentioned as the the breaches of misconduct. And then we would have administrative cause, which would be based on performance. So when we start with disciplinary, which is like I mentioned, though it's the one that most closely resembles the misconduct that Laura just mentioned. It includes things like theft, dishonesty, insubordination, harassment, and other behaviors that would breach workplace rules and policies, or that would breach the fundamental trust between the employer and the employee. In these instances, the focus is on the employee's behavior, whether the employee is intentionally or has intentionally committed a fault that therefore justifies a sanction on behalf of the employer. When the misconduct comes down to a breach of a policy or policies, the employer has to make sure that the employee was aware of whatever rule or policy that they breached. They have to make sure that this was clearly communicated to them and made accessible, because an employee cannot be disciplined for breaching rules they didn't know about. It would not be enough for an employer to allege the misconduct. They have to be able to prove that the employee actually breached this known policy or rule, and that this disciplinary measure was proportionate to the seriousness of that misconduct. Now, except in cases of serious fault, which we'll discuss later, the employer is expected to apply what we refer to as progressive discipline when addressing instances of employee misconduct. This essentially means going through a process of escalating sanctions, starting with warnings and then progressing all the way up to termination. The goal by implementing progressive discipline is to give the employee a chance to correct their behavior and to demonstrate that the employer acted reasonably and proportionately in response to that behavior. Now, when we turn from disciplinary to administrative, or as another word is called performance-based, like I mentioned, this is a fundamentally different concept from disciplinary dismissal in Quebec. Here, the issue isn't misconduct or blameworthy behavior, but rather the employee's inability or unwillingness to meet the requirements of their position. So most often it's underperformance or general incompetence. The key distinction is that an administrative cause applies when the employee is not at fault, but simply cannot fulfill their job to the required standard. Importantly, the difference between administrative cause and disciplinary cause is more than just theoretical. It has real consequences for the employer as it sets a different standard to their burden of proof. For administrative termination, the employer is required to follow a strict procedural process and meet 5 criteria before a tribunal will even consider upholding whether the termination was done for good and sufficient cause. So similar to what Laura was mentioning, the employer has to establish that they informed the employee of the objectives and standards that they have to meet, that they advised the employee of any deficiencies, that they provided the necessary support to help the employee improve, that they allow reasonable time to see this improvement, and that they clearly warn the employer that the employee that any further failure to improve will eventually result in termination. Now, in recent years, some judges have also considered a 6th criterion, namely whether this employer has tried to reassign this incompetent employee to another position for which they might be better qualified. Now, although the employer is not necessarily obliged to reassign the employee, some judges have ruled that they should nevertheless make the effort to assess whether there is another position available would be more better suited for this employee. For example, for an employee who's been holding the same role for many, many years. That said, the application of this 6th criterion are not uniform in case law and therefore are not considered to be a strict requirement yet. But as to the 5 steps, these are cumulative, so the employer has to demonstrate compliance with each and every single one of them. If one of these steps are missed, the administrative termination may be overturned, even if the employee is objectively incompetent. So in Quebec, we see, well, like the other province, we see that there are these 2 buckets. We have misconduct, which is intentional, and we also have employee performance. But either way, whatever path is chosen by the employer, there has to be a well-documented and proportionate process that is implemented. So, like I just mentioned, we have disciplinary and we have administrative terminations. But there's one situation where the processes that an employer must follow in terms of their burden of proof can be bypassed entirely. And this is when the employee commits what's called a serious fault. This is the most severe form of misconduct recognized under employment law, Quebec employment law. It refers to an act or an omission by the employee that fundamentally breaches the employment relationship. Typically, like I mentioned, this involves breaches of loyalty and honesty, and it includes more severe instances, including theft, fraud, violence, and gross insubordination. Any conduct that would cause an irreparable breakdown of the trust. In these cases where serious fault is at play, the employer is entitled to terminate the employee immediately without prior warnings, notice, or even progressive discipline. This is the only exception in Quebec to the requirement of providing statutory notice. So, in other words, even where good and sufficient cause can exist, employers must still provide statutory notice. Now, for a dismissal to be upheld on the basis of serious fault, Quebec courts require the employer to prove two things. First, that the employee's conduct was incompatible with the essential obligations of the employment contract, which, if we recall, under the code, employees have the obligation to act with prudence, diligence, and loyalty and maintain confidentiality both throughout their employment and thereafter. Second, that the breach that's committed by the employee is so serious that it is unreasonable to expect the employer to continue the relationship, even on a temporary basis. So the threshold for serious fault is very high, even higher than that for establishing good and sufficient cause.
Okay, so we now have a slide on the mitigating and aggravating factors that we had referred to earlier that the court will review when determining what the appropriate penalty may be in the circumstances. And so some mitigating factors would include the employee having an otherwise clean disciplinary record outside of the misconduct alleged. That can also include admission of their guilt, an apology for their behavior, basically taking ownership for their actions. Another is sort of lax supervision or past practice. So where the employer in the past did not terminate or discipline in the circumstances, but then is doing so in this circumstance. And then on the flip side, some aggravating factors that will work against an employee would be, obviously a lengthy discipline record, their misconduct being premeditated, not taking any responsibility for their behavior, and maybe even going so far as to being deceptive or dishonest during the employer's investigation.
So as you'll gathered by now, termination for just cause is not always the most appropriate disciplinary measure after a misconduct is identified, especially in Quebec, where administrative terminations are also possible. So where termination may not be justified, but some other form of discipline is appropriate, employers can manage employee performance through progressive discipline. Many times we see that employers prefer to avoid souring the employment relationship as long as continued employment is preferable to termination, and they may prefer to avoid progressive discipline until they want the employee out. However, progressive discipline is an important tool for employers to be able to improve performance and change or attempt to change the negative behavior, as well as reinforce these workplace policy expectations, and to create a record to support a termination for cause down the road, if and when the employment relationship does break down. So implementing progressive discipline is a very proactive way of treating a potential termination. It can also reduce litigation and liability risks down the line, while also providing employees with an opportunity to improve their performance and avoid termination in that meantime. So, what is progressive discipline? It is a structured process by which an employer imposes disciplinary measures of increasing severity to correct employee misconduct or performance, with the goal of correcting the behavior rather than punishing. But before implementing progressive discipline, an employer should ensure that they have established objectively reasonable standards of workplace conduct. They do so by communicating those standards to the employees, by training the employees on how to comply with the standards, and by supervising employees to ensure compliance with these standards. Ensuring that these steps are done beforehand are important because the requirement for these reasonable standards means the employer must have a legitimate interest in controlling or prohibiting certain conduct. And while some rules are obvious and don't require explanation, example, don't fight, don't steal, other standards may be more specific to the industry or the nature of the work being performed by the employee. For example, safe work practices, adherence to specific quality standards, or compliance with certain administrative procedures. These more tailored policies need to be brought to the attention of the employee in advance because, as we mentioned before, employees cannot be disciplined for failing to follow rules that they were never established or communicated to them. Now, when implementing progressive discipline, it's important to remember that the process will depend on the nature of the misconduct or performance issue. As we discussed earlier, a single flagrant act may justify termination for cause without progressive discipline, but in most cases, the measured step-by-step approach is most likely appropriate. Generally, the path looks something like this. An employer will start with a verbal warning, and even though it's verbal, it's very recommended to make sure it's properly documented in the employee's HR file. If the issue then persists, move to a written warning. If the problem continues or if the misconduct gets more serious, an employer could consider suspension, either with or without pay. Always trying to keep in mind that the disciplinary measure must be proportionate to the misconduct. Next, if the behavior still doesn't improve, issue a final warning letter. And this is where clarity is very important for the employer. They need to spell out exactly what constitutes further misconduct because the employee needs to understand what misconduct will trigger the eventual termination. And like Laura said, throughout this process, the disciplinary response should be tailored to the circumstance. So mitigating and aggravating factors should be considered to the specific individual that's concerned. There's no rigid formula to progressive discipline, and employers should avoid implementing it as a strict formula. Similar offenses may justify escalating penalties, but if time has passed or if an employee has shown improvement, maybe a different approach would be more appropriate. It's also important that employers not issue more than one final warning. The word final should in fact mean final. Employers should be clear about the expectations and the consequences. The goal with progressive discipline is to correct the behavior and not create confusion on behalf of the employee. So we can see here a case study of how progressive discipline works in practice. In situation 1, we see Larry missed a day of work, and he didn't call to explain why. In this situation, a coaching session may be enough to correct the behavior, letting Larry know the importance of calling in when needing to take a sick day, for example. After this, Larry will no longer be able to use ignorance as an excuse if the event occurs again. His manager can then go on to further disciplinary measures, such as a verbal or written warning. The goal, as mentioned, is to give the employee a chance to improve before considering termination. Now, in situation 2, we see Lucinda making the same reporting error 3 times after she's already been coached on the problem twice. In this situation, the best approach would most likely be to escalate the response. Since we see Lucinda has already received coaching and the errors are continuing, it may be time for a formal written warning. Now, the written warning should clearly outline the nature of the error, the impact these errors are having on the organization, and the expectations for improvement. It should also specify that the consequence, if these issues are not resolved, is that the further disciplinary action could include up to and including termination. Now, in Quebec, it would also be essential to determine whether the errors which are being made by Lucinda are intentional or whether they are performance related. If they are in fact unintentional, then administrative measures such as maybe implementation of a performance improvement plan may be more suitable than an immediate disciplinary measure. As a reminder, before any administrative termination, the employer has to follow the 5 procedural steps which are previously outlined. So in this case, they would have to communicate the expectations to Lucinda. They would have to identify the deficiencies, provide support and the training, allow for reasonable time to see the improvement in the training, and warn the employee that the job is at risk if the improvement does not occur. If after these steps we see Lucinda's performance still not meet the standard, then termination for good and sufficient cause may be justified. Now, of course, progressive discipline is not always appropriate. We've mentioned this. There are some situations across all jurisdictions where the conduct of an employee is so severe that it would become appropriate to skip certain stages of progressive discipline and instead proceed by termination for cause. Particularly, these are the situations of serious misconduct or serious fault, which we've already touched upon. It has the effect of permanently breaking the essential relationship of trust between the employee and the employer. There are, however, other situations where progressive discipline may also not be appropriate. And these would include, for example, management level employees. These employees are intended to set an example for other employees, and the employer should be able to hold them to a higher degree of trust, and they should trust them to not have to exercise the same amount of oversight as they would have to for a regular employee. That said, apart from a few exceptions, these employees should still be informed of the issues and provided with opportunity to improve. Another area where progressive discipline may not be warranted are zero tolerance policies. These policies are commonly implemented to prohibit the use of or being under the influence of, example, alcohol or drugs. That said, while zero tolerance policies may be appropriate in some situations, employers have to be careful to ensure that the policy does not inadvertently discriminate against an employee that requires accommodation. So ultimately, the decision to bypass progressive discipline should be reserved for the most serious breaches where trust and the employment relationship cannot be restored. Context and proportionality remain at the center, and the employer must always be prepared to justify the decision with clear and documented evidence.
Okay, so when we think about just cause, we typically think about the employee's behavior. But what's really important to keep in mind is that in any just cause assessment, the employer's behavior actually comes into question as well. And there are situations where certain employer behaviors can actually invalidate a just cause defense. And we'll go into a few of those situations now. I think one of the most important situations that often comes up when an employer wants to terminate for just cause, they will come to us and say, this employee has engaged in serious behavior. We want to terminate for just cause. We want to do it very quickly given the seriousness of the situation. However, the seriousness of the situation does not mean that the employer does not have to investigate. An employer needs to put the allegations to the employee so that they're given the opportunity to respond and to explain their behavior. They may come forward and say, I have an underlying disability that caused my behavior. There is some other reason for my behavior, including some mitigating circumstances happening at home. Whatever it might be, a failure to properly investigate can be fatal to a just cause allegation. Another situation would be, as we talked about before, failing to warn the employee that certain conduct could amount to just cause and lead to their dismissal. And this kind of goes in hand with condoning the misconduct. So if an employee has been operating in a certain way for a very long period of time, no one has said anything to them previously about their misconduct or the fact that their behavior is not appropriate, you have effectively condoned the misconduct. And so to then turn around and immediately terminate them for cause for misconduct that they've been engaging in for a significant period of time, that can often invalidate a just cause defense as well. So like I said before, it is often the case that just cause defenses can be invalidated by failing to properly investigate, which is what happened in this particular case. So in the Weyerhaeuser decision in 2022 in Alberta, we were talking about a 14-year service employee who was a sawmill shift supervisor. The employee had no disciplinary history or poor performance reviews until he got a new supervisor. The supervisor had issued a written warning in the past, citing poor performance. And then following this written warning, matters between the supervisor and the employee worsened. And the culminating incident in this case was the supervisor's allegation that the employee failed to properly deal with a small fire and didn't report it, or alternatively falsified a report about the fire. And the employee was terminated for cause as a result of this incident. The initial trial court and both the Court of Appeal determined that the employer did not have just cause to terminate, and the employee was awarded 1 year of damages in lieu of notice. The court found that there was a number of mitigating circumstances, but the most important was that the employer had failed to conduct an investigation and instead just accepted the supervisor's reasoning without asking the employee about it and putting the allegations to the employee. The court actually held that it may have been just cause had the employer actually investigated and proven its allegations through the investigation process, as opposed to just listening to the supervisor's version of events. So in terms of when we're talking about an investigation, there's a few best practices. There are often situations where there is no requirement to retain an external investigator, or an external investigator is not necessary. There's many situations where it's appropriate to do an internal investigation by someone in HR. It should just be someone who is removed from the situation. So if we're talking about a harassment situation, the alleged harasser should not be the individual conducting the investigation. It should be a neutral third party. Witnesses should be interviewed separately. Each individual who has information about the contents of the investigation should be interviewed separately. And the specific allegations about the employee should be put to them. They shouldn't be left guessing what the allegations are against them. They should know the case they need to meet. So they should know what is being said about them so they can appropriately respond. You also have to, during the course of the investigation, consider the employee's employment history. If there's other incidents of misconduct, they should be brought up in the course of the investigation as well. And unless it's absolutely necessary because you truly cannot get a hold of someone to interview them, don't make conclusions based on hearsay evidence. If someone says, X person said this during an investigation, you should likely go out and interview the other person to get their version of events as well, if that's a possibility. But the extent of an investigation really depends on the context of the allegations. If the allegations are very serious, an investigation could be rather lengthy and take a significant period of time. Whereas if the allegations are less serious, the investigation may be truncated or shorter. In terms of failure to warn, we've discussed this before, but really, particularly when it comes to performance issues, warnings give employees a chance to correct their behavior and to meet expectations before dismissal. And courts will look at whether an employee has been warned prior to their termination to determine whether or not termination was a proportionate response. If the employee has been notified that their misconduct is not condoned and the employer has notified them that termination is the next step and the employee continues to engage in the behavior, you're far more likely to be able to establish cause in that situation because the employee knows that their behavior is wrong and they're continuing to engage in that behavior. And again, a failure to warn may be seen as condoning the improper behavior. So condoning the behavior means essentially overlooking the misconduct and allowing the employment relationship to continue kind of as normal. And once this occurs, if you haven't previously disciplined for a certain type of misconduct, and then you discipline out of nowhere for the same misconduct, that could be seen as invalidating a just cause defense. Like the employee has to know what they're doing is wrong. If they've been doing something in a certain way for 10 years and all of a sudden you say, nope, that's offside, they have to know that. If you've issued formal or informal warnings to an employee, that typically invalidates the employee's allegations that their behavior was being condoned. And it's similarly, an employer actually has to know about certain misconduct in order to condone it. So if an employer doesn't actually know about the misconduct, they can't be seen as condoning the behavior. So certain behavior both before the misconduct and after the misconduct can lead to condonation. So the first, and this comes up often, failure to discipline other employees who have engaged in similar misconduct. So there could be just a personal vendetta against this one particular employee. Other employees have engaged in the exact same behavior and have not been issued discipline. If an employee can show that, it may invalidate just cause. Same thing as we've talked about, failure to warn. And then it is inconsistent enforcement of workplace policies. So if you have a policy that says there's zero tolerance for certain behavior, but it actually hasn't been applied to other employees in the past, it's going to be really difficult to rely on that policy to establish just cause for one particular individual. And then the same with after misconduct. So if you fail to comment on the misconduct despite full knowledge of it, that will be seen as condoning the behavior. If someone is engaging, if you're alleging someone has a history of significant performance issues, but yet you continue to give them raises, promotions, relatively positive performance reviews, which we see a lot, it's going to be very difficult to establish just cause. I think positive performance reviews is one of kind of the worst culprits because people have a hard time giving honest feedback in performance reviews, which is completely understandable. But those performance reviews are also often the crux of performance cases. And so if someone comes to us and says, well, this person has terrible performance, they have a history of performance issues, and then we look at their performance reviews and it's all fully met or stuff of that nature, then it's really difficult to try and establish just cause for performance issues. So to the extent it's possible to reinforce to people that it's important to be honest in performance reviews, I think that goes a long way.
Okay, so the difference between just cause and frustration of contract. As we've been discussing throughout this presentation, just cause is rooted in the employee's misconduct. On the flip side, a contract is frustrated where, without fault of either party, the contract can no longer be performed due to unforeseen or uncontrollable events. So, like any contract, an employment contract may be frustrated due to circumstances beyond either party's control. And in those circumstances, damages will not flow as a result of the termination of employment, with the caveat that an employee may still be entitled to their statutory termination pay and/or severance in certain circumstances, such as where the frustration is due to an illness or injury. So the court in Ontario has stated that frustration of contract does not require an act of the employer to trigger it. It occurs as a matter of law. And once the circumstances exist that affect the frustrating of the contract, it's deemed to be terminated. And as mentioned, a permanent disabling illness is an example of what might frustrate the employment contract. So neither party owes notice or compensation, and it's often referred to as a defense in a wrongful termination by the employer, especially where frustration arises following illness or injury of the employee. But as I mentioned, all minimum standards, legislation in all jurisdictions require that notice or termination pay be paid to an employee where employment ends. and most of these minimum standards legislation provide an exemption for termination entitlements under circumstances of frustration. However, certain jurisdictions, such as in the federal jurisdiction or in Ontario, these payments must still be made. In Ontario, for example, termination and severance pay is still owed under the Employment Standards Act, where employment is frustrated by reason of illness or injury of the employee. And keep in mind that where frustration is claimed to be due to disability or illness, the employer under human rights legislation will still first have the obligation of establishing that they have met their duty to accommodate up to the point of undue hardship before terminating the employment relationship. And I'll turn it over to Brooke to give some perspective from Quebec.
So in Quebec, the concept of frustration of a contract, as it's understood in the common law provinces, doesn't exist in employment law. Instead, under the civil code, it provides for what's known as superior force. This refers to an unforeseeable, irresistible, and external event that makes performance of a contract absolutely impossible. The threshold for invoking superior force is much higher than that for frustration of a contract in common law context. It's also important to note that just because it's superior force of a contract doesn't mean it's very commonly used in an employment setting. In practice, only truly exceptional circumstances, such as natural disaster or government order, can end an employment agreement or can potentially lead to the end of an employment contract in Quebec without liability. If an employee is unable to work due to illness or disability, the employer's obligation is first to comply with human rights law. So like Laura mentioned, they must be able to prove that they attempted their best to accommodate the employee up to a point of undue hardship. This can include reassignment to another suitable position, for example. Only when it becomes impossible for the employee to return to work and all these reasonable accommodation efforts have been exhausted, can the contract be terminated. But in reality, in most of these long cases of long-term absence or sick leave, they are resolved through this accommodation process, and then they go by the regular termination process. So with notice or indemnity where necessary. So we can see that the actual notion of frustration is much different in Quebec.
So as I mentioned, frustration is due to unforeseen or uncontrollable events. So foreseeable or self-induced events, on the contrary, will not give rise or support a defense of frustration. So courts have adopted an allocation of risk approach to this frustration analysis in the employment context. So if there is a risk that non-performance could be reasonably foreseen by the employer at the outset of employment, then it cannot be relied upon as a basis to assert frustration. So foreseeable risks have been found in the case law to exist where there's retirement or disability of the employer, where the employer is an individual, or in circumstances of strikes or labor disruptions. Likewise, self-induced frustration will typically not excuse non-performance of the employment contract. So an example would be an employer's voluntary assignment into bankruptcy does not frustrate the contracts of those employees. With respect to illness or injury, the courts have adopted a framework that asks whether the employee's incapacity is such that further performance of their employment obligations would be impossible or would be radically different than what the parties had originally contemplated and agreed to at the time of entering into the employment relationship. And the courts look at several different factors, such as the terms of the contract, including whether there's provisions for sick pay or disability benefits, how long the employment was likely to last had the illness or injury not taken place, the nature of employment, and then the nature of the illness or injury, including how long they've already continued and the prospect of recovery. So an employer should not terminate based on frustration without firm evidence regarding the employee's potential for recovery. This will require clear medical evidence that the employee's incapacity is permanent and or otherwise shows no indication of allowing the employee to return to work within within a reasonable amount of time. And so we often see that employers think after, let's say, like a 2-year limit, we're automatically into frustration territory. That's not necessarily going to be the case. It depends on what the medical is stating. If prognosis is still unclear, or there's if the employee is making a recovery, even if that's minimal, you may not be at the point of frustration. But if the medical is stating there's no chance of recovery at any point in the near future, you may be there. And so this is a case from the Ontario Court of Appeal where the court actually states that there's a fundamentally distinct difference between frustration and just cause dismissals. And this arose not in respect of a illness or injury, but with respect to a mandatory vaccination policy. And so Viewpoint provided services to various clients, including Bell. And Bell, like most employers, in 2021 implemented a mandatory vaccination policy, which required that all vendors that were providing services to Bell locations or interacting in person with Bell employees to be fully vaccinated. And so Viewpoint adopted a policy mirroring Bell's policy. And in that policy, employees that failed to become vaccinated within the communicated deadline would be prohibited from completing certain work for customers and might not receive assignments for lost work. So the individual in this circumstance refused to comply with the policy, and as a result, he was given 2 weeks' notice that his employment would be terminated. And then the employee then claimed wrongful dismissal. The court held that the supervening event was the implementation of Bell's policy, which was equivalent to a new regulatory requirement that was imposed onto Viewpoint, and that this policy was a radical change in the terms of employment between Viewpoint and its employee that was not foreseeable and was outside of Viewpoint's concern. So as a result, Viewpoint did not have an obligation to take other non-disciplinary measures before terminating the employee's employment for frustration, and they did not owe any damages as a result of the end of employment in those circumstances.
Okay, so I'm just going to briefly touch on after acquired cause. I won't talk about it for too long because candidly, it is quite rare to establish after acquired cause. Brooke has reminded me that the concept of after acquired cause does not even exist in Quebec. It is a common law concept. And so in relatively rare cases, an employer can actually establish just cause after they have terminated an employee without cause, based on employee misconduct that they did not know about at the time of termination. So the elements of after acquired cause are that the misconduct must itself be sufficient to justify a just cause dismissal. The employer cannot have known about the misconduct at the time of termination. So for instance, if you terminate an employee without just cause, and prior to the termination, you find out that the employee has been sending themselves hundreds of confidential documents to their personal email address, but you know this before you issue the termination letter, you cannot then turn around if you have terminated them without cause and then allege in a defense once they've filed a claim that the termination was with cause because you knew about that misconduct before you terminated. So you essentially waived your ability to allege cause in that situation. And then another thing is that you must act promptly once you've discovered after acquired cause, or you're risking a finding that you condoned or waived the misconduct and are just electing to go forward treating the termination as without cause. So there are a couple recent cases that actually talk about after acquired cause. So one of the more recent ones is Mitra versus the Royal Bank of Canada. In this situation, the employee was a managing director, so a relatively senior employee in the organization who was seconded from the UK to Canada. And his employment was terminated following an employer investigation and subsequent disciplinary proceeding regarding financial dealings with a subordinate. After the employee had already commenced litigation against the employer and at examinations for discovery, the employer learned that the employee had deliberately misled the employer's investigators about his investment. So they did not know this at the time of termination. It didn't come out until examinations for discovery. After that happened, the employer amended its defense to allege after acquired cause. And in that case, the court actually determined that there was cause for termination based on after acquired evidence. So they found that an employee's dishonesty, particularly a fiduciary or a senior employee, like in this case, they're held to high standards of integrity and honesty, as are all banking employees. So the court actually found that their dishonesty during the workplace investigation amounted to just cause in this situation because of the deliberate misleading that occurred. And so the takeaway being that where an employee's dishonesty during a workplace investigation is sufficiently serious and that dishonesty doesn't come out until after the termination, you may be able to allege after acquired cause. Again, it's a rare situation, but it does happen. And I think with that, I'll move on. We will move on to some example of recent cases so that you have a couple examples to take away before we move on to questions. Okay, so like we've talked about before, the recent case law, it confirms what we all know, that there's a very high bar to establishing just cause, but there are some commonalities in terms of the areas where just cause will be found, which is violence. Like, courts do not stand for violence against other employees, harassment, particularly cases of sexual harassment, significant poor performance, like we talked about, gross or serious performance issues, safety violations that have the possibility of injuring the public or other employees, serious breaches of policy, particularly banking policies, and very serious off-duty conduct as well, are certain situations where cause may be justified based on the recent case law that we've seen. So this case is actually a recent case from Ontario that deals with employee insubordination, harassment, inappropriate language use. So the employee in this case was a real estate agent who had previously been the owner of the company, which was a company based in Kenora, specializing in cottage sales in Northern Ontario. The employee essentially got into an altercation with one of his managers, where the manager took the position that the employee couldn't describe a listed property as a waterfront property. The employee clearly took offense to this, and he went into the supervisor's office in front of his wife, his young child, and two office staff, and actually told him to F you. I'm paraphrasing. And then also said, if you ever talk to me again like that, I'm going to hit you, or words to that effect. So actually implied that he was going to engage in violence toward his supervisor. After this misconduct, he also posted a number of inappropriate messages on the company's in-house computer system that could be seen and accessed by other staff. And in addition to this, he also caused a client who had a property listed for sale to switch to a competitor brokerage based on kind of deceptive information that he provided to the individual. So in this case, the court upheld the termination. They found that an employee swearing at an employer is an act of serious misconduct, especially for people who are in a professional environment. I don't think swearing on its own would have been cause for termination here, but when looked at in the context of all of the employee misconduct, they determined that swearing and threats of violence combined could constitute cause for termination.
So if we take now a recent Quebec arbitration case, this one does a good example of really illustrating the high threshold that is required for the employer when they want to go to just cause and when they want to go to termination for just cause and the requirement of progressive discipline. So in this present case, the employee had worked for the city of St. Augustine for about 10 years. During these 10 years, he had no prior disciplinary record. Over several years, he repeatedly sent and showed sexually explicit material to various colleagues, sometimes during working hours, sometimes outside of working hours. Some colleagues during this period told him to stop. Sometimes he complied, in some cases he didn't. In August of 2021, the city became aware of the employee's actions and launched both an internal and external investigation. During the investigation, the employee initially denied the allegations, but eventually admitted to most of the conduct. Importantly, he showed no remorse or regret for his actions. So based on these findings, the city decided to terminate the employee for cause, citing grave incivility as the reason and a breach of trust based on violations of workplace policies and the municipal code of ethics. Now, in response to this termination, the union filed a grievance arguing that progressive discipline should have been considered and that the sanction was excessive given the circumstances. So in this case, the key questions for the arbitrator was, did the employer establish just cause for immediate termination? Was the employee's conduct so serious that it justified skipping progressive discipline? And like I mentioned in Quebec, the threshold to skip progressive discipline really needs to be an instance of serious fault. So in this instance, was the relationship irreparably broken as a result of this employee's misconduct? Now, after reviewing all the evidence, the arbitrator found the allegations were fully proven. Yes, the employee had repeatedly sent and shown explicit material to the colleagues, and the conduct was clearly inappropriate and serious. However, there were several factors that should have been considered that were not considered by the employer. Namely, that the employee had a previously clean disciplinary record for over 10 years. None of the colleagues that were affected by these photos admitted to being traumatized or seriously harmed by the employee's conduct. And while the behavior was, yes, serious, it was not irreversible or comparable to what would be a most flagrant workplace offense, such as violence, fraud, or theft. And lastly, this employee's conduct did not irreparably break the breach of trust between the employer and the employee, and there was possibility for rehabilitation. So because of these factors, the arbitrator ultimately held that the city should have considered progressive discipline before resorting to immediate termination. So in the unionized or non-unionized settings, like I said, in unionized settings, they clearly implement the same practices as outside of this. So it's expected to apply discipline gradually, starting with these warnings or suspension before terminating employment. This is the expected standard, and it's not really the exception. So in this instance, the arbitrator overturned the dismissal and replaced the initial sanction with a 6-month unpaid suspension, ordering the employee's reinstatement. So we could see while just cause may be possible, the threshold and burden of proof on the employer is really, really harsh.
Hey, and so I think with that, given the time, we will turn it over to the question and answer period. I can see based on the Q&A function that we've received quite a few questions here. So I'll field the first one and then I can send some of them over to my colleagues here. One question that I noted is the question was, does all progressive discipline have to start at a verbal or written warning, or can the discipline be assessed based on the violation? So no, you absolutely do not have to start progressive discipline at a verbal or a written warning or coaching or whatever it might be. The level of progressive discipline to be applied is based on the misconduct. And so if someone has engaged in a very serious act of misconduct that is kind of on the edge of termination for cause, but you don't think you're quite there yet, it is perfectly appropriate to issue someone the next highest level of discipline based on the seriousness of the misconduct. So it's the context of the misconduct that should drive this sanction, as opposed to just feeling like you have to move through a certain step in the progressive discipline process. Now, there may be requirements in unionized settings under a collective agreement for you to follow a specific process, but typically in non-unionized settings, progressive discipline is entirely based on the seriousness of the misconduct at issue. One of the other questions we had, and Brooke, I think you could probably speak to this better, but someone asked if the Quebec TAT, can they reinstate someone back to their role after they are terminated, whether just cause or without cause?
So the simple answer would be yes. The primary mode of remedy that is awarded by the courts is reinstatement. They'll always favor this as the first option for an employee that is terminated. If it is established that the employee is terminated without cause, this is when reinstatement would be ordered. If it is established that the employee was terminated with cause, then reinstatement would not be ordered. The employee's case would have not been found. So if an employee does challenge their dismissal under the Act and it is found to have been made without good and sufficient cause, yes, the tribunal can order reinstatement. The tribunal can order it. An employee can elect not to do reinstatement. However, even if that's done, they can award back pay, like we mentioned. Similarly, sometimes a judge will find that the employee was unjustly terminated, but will determine that reinstatement may not be the most appropriate remedy because the relationship between the parties is not really what it was before. So in those instances, a judge may say, yes, the employee was terminated without just and sufficient cause. However, reinstatement may not be the most appropriate remedy. And in that instance, they'll be awarded back pay, like I mentioned, and potential additional compensation to make up for the loss of employment.
Okay, so the next question, which I will send over to Laura, is whether there is a guideline number for absenteeism that would trigger just cause.
Thanks, Jill. So no, there's not a particular guideline number that would trigger just cause. I think we should also be clear here that we're talking about culpable absenteeism as opposed to non-culpable absenteeism. So we've got an employee who is failing to show up to work without reasonable excuse versus someone who may be ill or may be absent due to another justifiable reason. And so, no, there's not a particular number. I think this will come down to several things, which is, are you following progressive discipline? So are you warning the employee? Are you giving them, are you setting out expectations clearly? Are you treating them similar to how you've treated other employees? So for example, has absenteeism been an issue with others, but it's been condoned? Even with this employee, has absenteeism been an issue for a while, but it's been condoned, and now you're taking a different approach. So I think setting the expectations clearly with the employee, giving them warning, and then determining how often and on what degree they're absent. There was one of the cases we didn't get a chance to go over, but you will see in the slides once they're circulated, where just cause was found for an employee that was absent, I believe, on 8 different occasions without excuse, and the employer found that they were not present, or sorry, the court found they were not present due to a second job that they took on.
So one of the other questions which I'll field relates to off-duty conduct, and we get a lot of questions about employee off-duty conduct, particularly social media posts. So the question relates to, for off-duty conduct, could this mean any type of language or posts on social media that are incompatible with the business's position or stand? The short answer to that is no. I think there has to be a recognition that employees do have freedom of speech. They're entitled to their own political views. I think you would actually really need to look at the context of any social media post. Um, if someone is just expressing an opinion, there may be no valid reason to discipline or terminate an employee. If someone's post is completely inappropriate, it's discriminatory, it engages in hate speech or inappropriate behavior towards the public more generally, like it discusses violence, stuff like that, then we may be talking about something that is just fundamentally incompatible. I think you need to look at whether or not the posts are actually fundamentally incompatible with the employer's views and sustained employment isn't possible. That's also a situation where you would need to sit the employee down and investigate and speak to them about their posts. It may also be a situation where a lesser form of discipline is appropriate, and you could say, we would like and ask the employee to remove the post because the posts are incompatible with the employer's views. Like, there may be other type of conduct or behavior that you can engage in before immediately moving to termination for cause. And there were, similar to what Laura said, there was also another case where some employees' online behavior, particularly in respect of how they were treating negative reviews written about their personal Airbnb, about how that impacted the employment relationship. And what the court found was that that off-duty conduct and their inappropriate comments were quite separate from the employment relationship themselves. So while the employee's off-duty conduct was inappropriate, it didn't fundamentally damage the employment relationship with their employer or the employer's relationship with its clients. So I think the answer in that question is quite nuanced. It depends really what the nature of the posts are, how frequent, and that type of analysis, I would say. So I think we'll probably have time for one or two more questions. The next one I'll throw over to Brooke is the question of whether or not, and I think Brooke covered this, but there was some question about whether or not we said that C-suite executives are excluded from the Section 124 recourse in Quebec.
Yeah, so just to touch point on that, the type of employee that is excluded from the Section 124 recourse or the recourse against termination without made without good and sufficient cause is senior managerial personnel. So this term is not defined in legislation. It's been interpreted through case law. So while, yes, generally speaking, C-suites would likely fill this definition, what courts will really look at is to see, was the employee a member of senior management? Did they report directly to the owner, to the president, to the board of directors, to the managing director of the company? Did they participate in the company's direction, in the major orientations of the business, strategic decisions concerning the profitability of the business, and its general strategies and policies? The employee has to have had significant decision-making authority, a lot of autonomy in the business, and the decisions that they would make independently need to have an impact on the business itself. So that's why the term senior manager is a very general term, very broad. So just because an employee is titled a manager does not necessarily mean that they would fall under what is a senior managerial personnel under the Act and preclude them from filing a recourse under Section 124. So that's just something to keep in mind for an employer to know that just because you have 5 managers does not mean that all those people will be automatically excluded from protection of the Act.
And that analysis that Brooke just spoke to under Quebec legislation is very similar to the analysis under the Canada Labour Code for the managerial exemption to the unjust dismissal protections. It is a very high standard. The fact that someone is termed a manager does not mean that they will be found to be a manager under the legislation. They really have to have a significant amount of direction and control, particularly in respect of hiring, firing, budgetary decisions, that type of stuff. So it's a very similar analysis under the Canada Labour Code. I think I'll take the one last question here before we break. One question was, how long are written warnings valid for? For example, if you have a long-term employee. That question is, if we're talking about a unionized setting, that question is often answered by the collective agreement. There's often a sunset clause in the correct collective agreement. Very frequently, it's 24 months where someone's discipline will fall off the record after 24 months. In the non-unionized setting, there is generally no limit on how long written warnings or prior discipline is valid for. The courts will look at it contextually. If you have a long service employee who's been there for 20 years and they had a written warning 5 or 10 years ago that is unrelated to the misconduct at issue, a court may not put much weight on that prior written warning. Technically, it doesn't fall off the disciplinary record, but oftentimes courts will kind of treat employees as having kind of like a built-in sunset clause, and they will probably put less weight on progressive discipline that was issued significantly before the misconduct in question. And so with that, that brings us to an end of today's session. Thank you so much for joining us. On your screen, you'll find details on claiming CPD credits for Ontario, Quebec, and British Columbia. And we've also shared the links in the audience chat. And if you don't get a chance to claim your certificate right now, do not worry. They'll be sent out next week. And if you missed any of our LEHR webinars this year, you can watch the replays anytime on fasken.com under events. So thank you so much for being with us today, and we hope you have a great afternoon.